Hello aspirants, I am Pallavi Rai. I am here to discuss with you Civil Procedure Code 1908. Today we will discuss about the very important chapter which is Plaint because it is very important for upcoming examination. So in which section and which order this specific provision regarding plaint has been dealt with. Section 26 along with order 4, 6 and 7 has the provision regarding the plaint. Section 26 will be read with order 4, 6 and 7. What section 26 says? Section 26 says that every suit should be instituted by the presentation of plaint, and its subsection 2 says that in every plaint fact shall be proved by affidavit. But we have amended the provision in 2015 and added a proviso in its application to any suit in respect of commercial dispute of a specified value. We have to provide an affidavit in the form and a manner as prescribed under Order 6, Rule 15A. So, what the provision of Section 26 says that suit must be instituted and it must be instituted through plaint, and plaint in every plaint fact shall be proved by affidavit. Now we will move on to the order 4. Order 4 deals with institution of suits. So the first rule of the order 4 says that suit to be commenced by a plaint, and every suit shall be instituted by presenting a plaint in duplicate to the court. The duplicate word here is important for any examination, any upcoming examination. And second sub rule of rule 1 says that every plaint shall comply with the rule contained in order 6 and 7. And third sub rule has the provision that plaint shall not be deemed to be duly instituted unless it complies with the requirement specified in sub rule 1 and sub rule 2. So this is the first rule of order 4. What the rule 2 of order 4 says, that order 4 rule 2 says that the court shall cause the particulars of every suit to be entered in a book, and that book will be called the register of civil suit. And such entry, what entries? The particular of every suit shall be numbered in every year according to the order in which the plaints are permitted. So this is the order 4 regarding the institution of suits. Now we will move on to the order 6. Order 6 talks about the pleading. So what the pleading here means? Pleading means both plaint as well as written statement. So rule 1 has the provision regarding the pleading. Rule 1 says that pleading shall means plaint and written statement. Rule 2 is also very important rule, and it is substituted by Amendment Act 1976. What Rule 2 says? That pleading to state material fact and not evidence. So the every pleading shall contain only a statement of material fact in a concise form, and on which party pleading relies for his claim or defense, but not the evidence by which they are to be proved. What does here means? Pleading shall contain a material fact which is in a concise form, for which party relies for his claim or defense, but not has to contain the evidences by which they are to be proved. And sub rule 2 of rule 2 says that every pleading when necessary be divided into paragraph, and that paragraph numbered consecutively, and each allegation being so far as it is convenient contained in a separate paragraph. What does here means? That pleading must be divided into paragraph and numbered, and each allegation shall be contained in a separate paragraph. What does sub rule 3 says? Date, sum and number shall be expressed in a pleading in figure as well as in words. This is the rule 2 of order 6. Uh, Third rule says about form of pleading. The form in Appendix A shall be used for all pleading, and when they are not applicable, the form of like a nature shall be applicable. So this is not very important. Then after rule 4 will be the important particulars to be given when necessary. So the rule 4 says that in all cases in which party pleading relies on any misrepresentation, fraud, breach of trust, willful default, or undue influence, and in all other cases in particulars may be necessary, it shall be stated in the pleading. And that particular shall be with date and items if necessary. So this is the rule 4. The next important rule is rule 6. What rule 6 says? Rule 6 says about condition precedent. The performance or occurrence of which condition precedent is intended to be contested shall be distinctly specified in his pleading by the plaintiff or the defendant. And averment of the performance or occurrence of all condition precedent necessary for the case of plaintiff or defendant shall be implied in his pleading. Next important rule is rule 16. Rule 16 of order 6. What does rule 16 says that? Actually, this rule is substituted by Amendment Act 1976. And what does this rule says that? The rule says that the court may at any stage of proceeding order to be struck out or amended any matter in any pleading. It has two or three sub rule which may be unnecessary, scandalous, frivolous, or vexatious, which may tend to prejudice, embarrass, or delay the fair trial of suit, and which is otherwise an abuse of the process of court. This must be strike out from the pleading or amended. Next important rule is rule 17 of order 6. This is all about amendment of pleading. The court may at any stage of proceeding allow either party, whether plaintiff or a defendant, to alter or amend his pleading in such a manner on such a term as may be just, and all such pleading shall be made as may be necessary for the purpose of determining the real question of controversy between the party. And it has a proviso annexed to the rule. What the proviso says that? The proviso says that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that party could not have raised the matter before the commencement of trial. Okay. So what the proviso says that no application for amendment shall be allowed after the trial has commenced, and unless the court comes to the conclusion that at any cost, at any rate, the party couldn't have raised the matter before the commencement of trial. So this is all about rule 17, amendment of pleading. So the next and the last important rule, which is rule 18 of order 6. What does rule 18 says? Failure to amend after order. If party has obtained any order to amend pleading and he has not amended, if court has a specified period or within 14 days, after the expiration of that period, party will not be permitted to amend unless the time is extended by the court. What does here mean? If there is no specified period by the court, the person will be given 14 days to amend. If he doesn't amend after the expiration of 14 days, he will not be permitted to amend his pleading unless the court thinks that it is sufficient to order him, and without due diligence he could not amend the pleading So he will be permitted to amend the pleading after the expiration of period if court satisfies. Now we will move on to the order 7, which specifically deal with plaint, and all the rule regarding this order has been dealt with a plaint. So this order is very important, and we need to know about the each and every important rule of this order. So let's get started. So let's get started with the rule 1. Rule 1 deals with a particular to be contained in plaint. If you have seen ever a plaint, you have seen the name, what is written on the plaint. First you have seen the name of the court, the name and description and place of residence of the plaintiff, the name, description and place of residence of the defendant as well, and where the plaintiff or the defendant is a minor or a person of unsound mind, the statement to that effect. And next, the fact constituting the cause of action when it arose, it will be mentioned. After that, the fact showing that the court had jurisdiction, it will also include it. And where the relief which plaintiffs claim, this is if any relief the plaintiff has to claim, it will also mention in the plaint. And when plaintiff allow a set off or relinquishment of portion of his claim, the amount so allowed or relinquished as well mentioned, and a statement of the value of the subject matter of the suit for the purpose of jurisdiction and of the court fees, it will also be included. So the particulars contained in the plaint will be the name of the court and name and residence and place of the parties, and in case of minority or unsoundness, a statement to that effect. Fact constituting the cause of action, it will also included in that plaint. Relief which is dealt with under rule 7, it is also be mentioned in that plaint. If plaintiff allow any kind of set off or relinquishment of his claim, the amount so allowed or relinquished, and statement to the value of subject matter and of the court fee, this will be included. Second important rule of order 7 is in suits of money or in money suits. What will be the mention? Where the plaintiff seeks the recovery of money, the plaint shall state the precise amount claimed. But where the plaintiff sue for mean profit or for an amount which will be found due to him on taking unsettled account between him and the defendant, or the movable in the possession of defendant, or for the debt of which the value he cannot estimate after the exercise of reasonable diligence, the plaint shall state approximately the amount or value sued for. What does here means? In money suit, if plaintiff seeks recovery of money, he will mention the precise amount. And if suit is for mean profit or unsettled account or for possession of or for movable in possession of defendant or for debt which value he cannot estimate, he shall state approximately the amount or value sued for. This is all about money suit. Next, an important rule of order 7 is rule 3, where the subject matter of suit is immovable property. Last rule we have seen about the money suit, there must be precise amount stated in plaint, and where the subject matter of suit is immovable property, what will be in the plaint, what the plaint contain. If the subject matter of suit is immovable property, the description of the property of so much that it will be sufficient to identify it. And if such property can be identified by the boundary, by the khasra number, by the khatoni number, or number in a record of settlement or survey, the plaint shall specify such boundary or number. Next, an important rule is rule 4. Rule 4 says when plaintiff sue as representative. When plaintiff sue as a representative character, he must show that he has an actual interest in the subject matter as well as what step he has taken to enable him to institute a suit. These both things have to mention in his plaint. Next, an important rule is Rule 6, in which ground of exemption of limitation is given. We have already read in Limitation Act Section 5, which talks about condonation of delay. So, if court satisfied that there is a ground for condonation of delay, he can exempt us and he can permit us to file a suit after the expiration of period. But Section 6 says that where the suit is instituted after expiration of period prescribed by law of limitation, the plaintiff shall show the ground upon which exemption from such law is claimed. Next important rule is Rule 7, in which says relief to be specifically claimed. What relief you want from the court, you must state in your plaint. This is all about Rule 7. So the next important rule is Rule 10, return of plaint and its procedure. What Rule 10 says? The plaint shall at any stage of the suit be returned to be presented to the court in which suit have been instituted, but it must be subject to the provision of Rule 10A. Rule 10A says? Power of court to fix a date of appearance in the court where plaint is to be filed after it returned. So the rule return of the plaint is plaint can be returned at any stage and it is presented to the court in which the suit should have been instituted. And what the procedure of returning the plaint? The judge shall endorse thereon on the date of his presentation and return, and the name of the party presenting it, and the brief statement of the reason for returning it. It is the basic procedure of returning the plaint. So the most important rule is Rule 11 of Order 7. Rule 11 of Order 7 says that in what circumstances plaint shall be rejected. First, when the plaint doesn't disclose a cause of action, where the relief is claimed but it is undervalued, when the relief claimed is properly valued but the plaint is returned upon the paper insufficiently stamped, and when the suit appears from the statement in the plaint to be barred by any law, where it is not filed in duplicate, it doesn't comply with Rule 9 of Order 7. So all these grounds, on all these grounds, the plaint should be rejected. And Rule 13 says that where rejection of plaint doesn't preclude the presentation of fresh plaint. So if the plaint is rejected on the ground given in Rule 11, the rejection of plaint on any ground shall not of its own force preclude the plaintiff from presenting a fresh plaint in respect of the same cause of action. So the plaint doesn't, so the rejection of plaint doesn't preclude the presentation of fresh plaint. So the last important rule of Order 7 is Rule 14, the production of document on which plaintiff sue or relies. Where the plaintiff sue upon a document or relies upon a document in his possession or power in support of his claim, he shall enter such document in a list, and when any such document is not possession or power of plaintiff, he shall state in whose possession or power it is. And this is all about the Order 14. So this is all about the plaint, and so we will discuss the next in the next video all other provision which is important for